Well, hello everybody. We are live a little bit late, and I apologize for that. This has been a whirlwind of a day. I was in court for a couple of hours earlier, and we had all sorts of drama today. But we're here at the pretty much the end of the day, ready to go live with today's topic. And so I am excited about today's show. It's the last YouTube Live that we're going to have for 2025. We're talking about pets and the kinds of limits that you can place in a lease pertaining to pets. Now, look, I recognize that, across different jurisdictions, there's going to be certain limits of certain things you can and can't say. And so I'm going to talk generally about the kinds of things, the kinds of limitations you should be considering. Certainly, certain jurisdictions are going to limit, definitely exotic animals and things like that. But, and other places are going to be a little more relaxed. So, you're not going to get a whole lot of alligators in North Dakota, nor are you going to get a whole lot of elk in southern Florida. But again, so I'm going to speak generally about the kinds of limits you can place on pets. And we are going to talk a little bit about emotional support animals and the way they kind of figure into this idea of animals on the premises, because a lot of you just have a very firm position. I don't want anyone with a pet or an ESA renting from me. And then I get questions like, well, am I in violation of federal law by, prohibiting animals or pets in any way? And so I want to talk about those things. Additionally, I've got a set of preset questions that are given to me. And you may be asking, well, Ernie, how do I get a question in front of you if I wasn't able to get one of the presets? Well, I'm glad that you asked, because as always, and here we have our first hello. James, it's good to see you. You have the opportunity through the chat feature to throw in your questions and ask me a question you didn't get to ask. But if you can, and you're part of our Texas Landlords Facebook group, that's one place where you can put it. Additionally, if you are on our mailing list, definitely you have access to us. And if you see along the bottom of the screen here, there's a ticker there that shows how you get a hold of us, either through text or phone. You can reach us. You can also shoot us an email and say, look, I'd like to get on the mailing list in the event that you guys put a question out there, or I've got a question that I'd love to see answered on YouTube Live. And so if you're interested in getting on our newsletter, or if you've got a rental property in the state of Texas and would like to get in our Facebook group, I welcome you to go check that out. We've got over 8,000 members in that group. It's a really great, helpful group of like-minded individuals who answer each other's questions, help each other out all over the state of Texas. And so that's an excellent resource for you. I welcome you to check that out. So we are going to go ahead and begin our topic, and it's about the kinds of limits that can be placed on pets. And so I want to go ahead and, go ahead and get into that. But again, if you've got questions and you were unable to get yours in, throw it into the chat. I promise you I will definitely answer those questions that are in the chat, because that's what we're here for. I'm here to do my best to answer as many questions as I possibly can, and I look forward to doing that. So let's go ahead and get started with our first point, having to do with limitations that we can place on pets. And, I talked a little bit about the ESA. And so, I want to give you advice that's helpful. And so the first thing that I want to point out is that the federal law is not absolute. At no point does it say you have zero power. But, you definitely want to, when you're thinking about, the kinds of restrictions that you have, you want to be able to say, look, if it's not a reasonable accommodation, and it might be unreasonable to you, so before we get too deep into these points, if it turns out that an accommodation is just not reasonable, then you don't actually have to grant that accommodation. There are some things that simply violate reasonability. So, for example, I had one. I had one client who said, I'm severely allergic to pet dander. And and I manage my own properties, and I've got a pet in the property, I won't be able to check it out. I'm going to have to pay somebody else to go in there. Why should I be required to allow somebody an ESA when it is unreasonable for me? It's a health risk for me. Does the law not see that? Well, actually, the law does. And remember that if your tenant having a pet, when you otherwise ban pets or animals on your property, if them having a pet is unreasonably burdensome to you, you can actually say no. And that's the first thing that I want to mention, just to kind of get ahead of this, is there are no absolutes in the federal law. It has to be a reasonable request, really, before you're actually subject to it. So have that in mind. If you're unsure as to whether or not the request is reasonable or not, well, you might want to, confer with an attorney to make sure that what you got in front of you is a reasonable request, and that you're otherwise required to allow that particular tenant to have that pet because you don't meet some kind of qualifying reason to deny them. So point one, you want to limit, if you are going to limit. So again, we're not talking about ESAs anymore. So we just kind of briefly mentioned it. If it's an unreasonable request, you're not required to accommodate it. But let's assume it's a reasonable request. Let's assume then we're not even talking about ESAs. We're talking about pets. So these are people who you allow to bring animals on. Yes, you can have an absolute ban, and unless it's an ESA and there's other complication to that. But what if you do allow, what sorts of limits can you reasonably place? And here's some things for you to consider. These are not absolutes, just like the federal law. I'm not giving you absolutes here, but you can limit pets to those that have been disclosed to you and have been approved by you. That might include, for example, pets that have shot records, pets that are not otherwise going to be a liability to you. You want every pet documented, and you want only those pets that you reasonably expect to be there, because you've got to consider your liabilities. And if somebody's just bringing in pets or pet sitting for somebody else, and there's nothing featured in their lease, there's no pre-approval by you, that's a risk. And don't just let it slide that your tenants are putting you at risk. Make sure you address it and make sure they know that you're limiting them to access. If it's a pet that you've pre-approved, if it's a pet that has been disclosed to you, then yeah, you can allow it. Anything outside of that is a violation that should be met with a notice of default. And it's important that you get those out there. It's important that you, let your tenant know where the lines are, because otherwise, they're going to walk all over you. And, ultimately, in this perspective, they're going to open you up to liability, and you definitely want to avoid that. So, second point, let's see. Whoop. Limit the number of pets to what is reasonable. We don't all have the same homes, right? And so if you've got different units that are of different sizes, you may let something out in a rural area have, that individual have more pets than someone in a small apartment. And so understand what's reasonable. Make sure going in what's reasonable, so that if people ask, do you allow pets? It's not some open-ended question and they've got 4 gigantic dogs, right, in a small apartment. They may not see how that's unreasonable, but you should see that ahead of time to make sure that you've put a reasonable limit before the question ever comes up. Like, why would you think this was okay? Well, you said that I could have pets. Again, put these reasonable limits in there ahead of time to prevent any kind of, mix-up, having to do with with pets. So, all right, close with Unique. I'm Unique the Realtor. Great. I've got a question for you. I will definitely address that later on in the live. Nivimich. Tenant said she did not have any pets. Once she got in the home, she sprung up. I have an ESA. I want to bring here. And unfortunately, that does happen. And it's not necessarily against the law, especially since the law allows that. NL 1234, message retracted. Okay, well, I won't answer that. Close with Unique. I put my question in Monday, Tuesday. Got it. Plano Cypermission, Harris County 6671. Okay, I'm not even going to try to do that again. Am I required to have parking towing signs even though it's not a commercial property? If yes, what code governs the sign requirement and terminology? Can I tow the illegal autos? If you're going to tow, you need signage. Even though you're not a commercial property. So residential units have to have signage if you mean to tow. What I tend to recommend to landlords is, like pets, as I was describing, disclosed vehicles. Make sure that your lease mentions that they are limited, number one, in where they can park, and they are limited, number two, in the vehicles that are allowed to be on the premises. So you want to know what vehicles are going to be there. You want to know where they can park. Now, understand, you can't cause a tow off of a public street. And so, you might run into HOA issues. And if that's the case, disclose that to your tenants. But, I would make sure that I know what I'm doing when it comes to towing. And it's hard to address that in this kind of Q&A. I would need to know what the place looks like and what you mean. Like, do you have a parking area, assigned to your rental units? If so, then yeah, you can control who's there and who's not. And you can have signage that says, look, if you're not authorized to be here, you will be towed. But definitely you want signs out there so the general public is not otherwise harmed. You also want that data in your lease so that you can stand by it at any time when your tenant, it becomes subject to those restrictions. So let's see what else we got here. Did not know that a service animal can be refused. You rock. Well, I'm glad that's helpful. Yeah. Again, I wouldn't be so cavalier with rejections, but again, it is something that a landlord can consider. Is this reasonable for me? Because if it's unreasonably burdensome, you can deny it. If a certain animal is exotic, peacock, raccoon, beaver, snake, can landlord refuse? Yes. I mean, if the law doesn't allow you to do it, then you can't be required to permit it. Somebody would have to have a real specific reason why they have an emotional support peacock in an urban area where such a bird is not allowed. So again, if and I use the term exotic, kind of generically, certainly nobody has, well, you probably aren't going to see an emotional support rhinoceros. Right. And so, and in most jurisdictions, an animal of that size is not going to be allowed. And so if it violates the law, again, that's an unreasonable request. So let's go ahead and continue. We are at the next question. What other limits? Limit the size of pets. So you may say, look, I'm comfortable with a 30-pound dog, but once you start getting into the 80 and 90 and 100-pound dogs, my unit isn't appropriate for X, Y, and Z reasons. Perfectly valid, and you want to be upfront. If you've got limits, you want to be upfront with your prospective tenants and then be consistent. This is a perfect place for you to put it in house rules. It's also a good screening device because there are certain tenants that know, look, if they don't let me have my two 80-pound dogs, then why would I even apply? Why would I waste money? You don't want this to be a surprise later and try using well, come on, it's common sense. Of course I wouldn't want such a large animal. There is no such thing as just common sense when it comes to these limits. You want to be explicit. Don't take it for granted that everybody knows what your limit is, because everybody's limit is a little bit different. If you are going to place a limit, always make it explicit and have a justification for it. You don't want to just be arbitrary. Why is it that you're placing this limit, and just stick to it? Know what it is and be explicit. Make sure your tenants or prospective tenants know ahead of time. Next, limit their access to the entire property. And so here's an easy one. Let's say you've got tile on the first floor and carpet upstairs. You could say, for example, you're allowed to have pets on the tile, but no pet is allowed on the stairs that are carpeted. No pets are allowed upstairs where the bedrooms are. And that may be a turnoff to your tenant. They may say, you can't restrict the way I use my pet or where I take my pet. If my pet's allowed here, I can give my pet free rein, but that's not true. Now, an emotional support animal might be a little bit different. But a pet, you can definitely restrict and say, no, I'm not going to allow pets upstairs where there is carpet. If you want a pet, you're allowed to have a pet, but only on the first floor or only in the rooms that are tiled, right? And so by having these restrictions, you're likelier to protect your most valuable asset, which is that rental property. But again, you got to be upfront. You got to be precise. It's got to be in your rules, stated in black and white. And it should be stated in the screening process. If you do allow pets, what are your limits? Make sure that you're mentioning these as a pre-screening method, but also, just as a good landlord, to make sure that your tenants are well aware of what you will and will not accept from them and their animals. And finally, limit damage to zero. I don't know how many times I get landlords who come to me frustrated at the end of the lease, once the tenant has left, and there's been extensive pet damage. But I ask, well, when did this occur? Did this all occur in the very last month? Because unless it did, and if it occurred earlier and you knew about it, but you just kind of let it go, figuring I'll take it out of the security deposit, well, that doesn't put you in the best position. The best position is always the moment you know that damage is present, you issue a notice of default to your tenants. You issue that notice because you want it to be dealt with. And the best way to deal with it is you go in there, you say, here's a notice of default. You have violated the lease due to this damage. I'm going to fix it right now. I am not going to wait to the end. I'm going to fix it right now. Along with me urging you, don't let your animal do this again. And this applies to ESA and to regular pets. An emotional support animal doesn't have carte blanche to destroy your property. So if their animal has harmed your property, you're going and issuing a notice of default for damage. You are repairing it and letting them know, I'm sending you this bill. Whatever it costs me, it's going to cost you. And if they refuse to pay, that's another notice of default. If they refuse to pay but pay their rent, guess what? If you've got an application of funds clause, whoop, pull it out of that and then give them a final notice saying, look, now your rent is deficient. You were supposed to pay it the first time. You failed to do it. I gave you a reasonable amount of time to do it. It's reasonable for me to ask for this because your animal, damaged my property, and now you have violated the lease for non-payment of rent. Please cure this violation. Otherwise, I'll be forced to evict. And if they're headstrong and stubborn and say, you're going to have to evict me, then do it. Don't just tolerate it. You should have a zero tolerance for damage to the property caused by the pet. Because guess what? That's not ordinary. It's not reasonable for you to just accept it, even if they paid a pet deposit. We're going to talk about the difference between pet deposits and pet fees a little later in one of the questions that was given to us. But, there's just no room, I think, for, tolerating, damage to the property. There's in no way is it a good idea. And so don't tolerate it. Don't excuse it. Don't let them say, well, I'll take care of this at the end when I clean up. Not good enough. Repair it immediately. Issue notice. Stay on them. Make sure it's not repeated, because if it is, again, this is probably somebody who can't control their animal, and that's somebody who's just going to make it worse. I guarantee, I've seen it too many times. They're just going to make it worse. Don't let them. Make sure you get rid of them before they've given you an issue that is out of control. Certainly, you don't want to wait until, after they're gone, and then you're dealing with an insufficient deposit amount to cure whatever defects they've caused because they were unable to, maintain their animal in a good way. And so, I'm one of these people who's like, I don't believe, your kids are bad. If your kid's destroying the property, you're bad. You got to be able to manage these children to make sure that they're not doing things they shouldn't be doing. And if they are, then you got to pay for the repair. And so if you've got a pet that you can't keep under control, I don't believe that dog's a bad dog. I believe you might be a bad dog owner. So don't, absolutely have a zero tolerance for pet damage. Get on it, issue notice, and make those repairs and bill your tenant. So let's go ahead and get into the questions. We have question number 1 here, and here we go. Zoila M. Duras. How should I respond to a tenant request to break the lease suddenly due to job loss and moving out of state? The request was placed 3 days before the intended move-out date. Well, first of all, what does your lease say? Your lease probably, and this is just a guess here, but your lease probably requires more notice than that. So that's one thing. Secondly, how much time is left on the lease itself? And then third, what makes sense for your situation? And the reason I mention all of these is because, if they've got 3 weeks left on their lease and they were supposed to give you a 30-day notice, I don't know that it's worth the fight. And so, they want to leave a little early and maybe skip out on the last month's rent. It's not legal. It's not something that I really advocate. But if the house is otherwise in good condition, you can work out a resolution with this tenant. My guess is that's not what's happening here. My guess is what's happening here is there are 4 or 5 months maybe left on the lease. They certainly didn't give you 4 or 5 months worth of notice, and they're certainly not intending to pay 4 or 5 months worth of rent. So what do you do? Well, you definitely want, once they've gone, to clean up the place, reset it, bring it back up to tip-top shape, and put it on the market, find a new tenant, and mitigate your losses. The law requires, in most jurisdictions, for you to do your best to find a new tenant and limit your losses. But figure out ultimately what your losses are, and then calculate your damages. How much are you holding in a security deposit? Did it take you 3 days to find a new tenant, or did it take you 3 months to find a new tenant? That's going to compute to a greater loss the longer it takes for you to find a new rent-paying tenant. Was there damage to the property? You're going to calculate in full exactly what your economic loss was from this contract. And then you got to ask yourself, is it worth going after someone who doesn't have a job and has moved out of state? And generally speaking, the answer is no. It's not worth it. It's unfortunate that it happened this way. Do your best to, mitigate your losses and just move on. Unfortunately, sometimes, this kind of garbage happens, and, maybe it's not their fault, but it's certainly not yours. You just have to deal with it. And so wrap this one up and move on. As far as somebody asking you, hey, I'd like out, I don't tend to take that statement lightly. And so, somebody wants to terminate the lease early, it's going to cost you money, right? I don't know if it's, like I said, 3 days or 3 months. It's going to be some amount of time when you're not getting rent, probably, unless you've already got somebody who's really interested in getting in to your unit. And you might have a really hot unit that doesn't stay available for very long. And if that's the case, and you can estimate, look, I'm likely going to lose X in rent, or you've caused this amount of damage, or, we can calculate this later. And as long as you agree to pay it, I won't come after you for it. But every case is a little bit different. Certainly, if they're a terrible tenant and you're not likely going to just let them go, right? If it's worth it getting rid of a terrible tenant. I wouldn't wrangle with somebody who you're not going to get anything from. If it's someone who's reasonable and somebody who's willing to pay the full amount of the cost of an early termination, then figure out what that's likely to be, and then draft up an early termination agreement that suits you both. They want it to end early and you don't want to lose money. Come up with a plan that suits the both of you. Perfectly fair, perfectly legitimate, and the best way for you to deal with these situations. Because you might be like it is right now in the worst time of the year to find a new tenant, or you might be in the middle of summer, the best time of the year to find a new tenant. And that's going to mean a different market, and it's going to mean different variables for calculating what your losses are. But you always want to take into account, what's it going to cost me to find a new tenant? And then you can, again, come up with a reasonable settlement based on that. So let's see what else we got here. Question the next. So, I need to file a lien on a previous... tenant. They have an outstanding water bill of $4,710, which is in my name. What do I need to do to clear this balance? A lien? Well, a lien's only going to get you so far, and you can't just create a lien like this, out of whole cloth. That's not how that works. You would need a judgment against the tenant to create a judgment lien. You would need some kind of written agreement with them to get some kind of recordable lien that you would put against possibly their person, maybe against some kind of collateral like a piece of real property or a substantial piece of personal property like a car or a boat or something. My real question is, how did it get this bad? How did it get so high without being addressed first? And so when it comes to utilities and a tenant's utilities being in your name, the first things I ask are generally, why does it have to be that way? Is there any way to get these utilities out of your name and not have this incident repeat itself? Certainly, if you can lease property without putting the utilities in your name, that's always the best method. But if you have to keep them in your name, you got to keep a close eye on that bill and never let it get quite this high. The next thing is, what does your lease say about unpaid utilities and your ability to cut them off, which is not generally something that I recommend. But your lease should have some pretty strong languages about default and what failure to pay utilities can result in. This is probably somebody who could have been evicted a long time ago. And unfortunately, if you can't find them and they don't have the money to pay this might just be something as the landlord, Monica, you might just have to, take this one on the chin. I just don't know that you're going to be able to force this tenant. And certainly you can sue them. If you can find them, you can sue them. But if they don't have the money to pay it, it might be difficult for you to squeeze blood out of this particular turnip. And so I don't know that you'll be able to get it. I don't know that a lien is really going to help you. However, if this is a person of means and or they have, assets that potentially can be, seized and auctioned off to pay off this debt, yeah, I mean, that's definitely a possibility. But again, if it's somebody, somebody who's run off, who you don't even know where they are, you don't know where they live, you don't know where they work, you don't even know if they're still in the local area, And even if you did know, if they just don't have the money, they don't have the assets or the funds in an account to cover these fees, then you may never be able to recover these damages. And that's unfortunate, but that may be the truth here, especially if this is in Texas. Unfortunately, the laws here don't allow you to garnish wages. A lot of personal property is otherwise exempt from seizure. And so, yeah, it's difficult. It's always easier to collect a maximum amount from a tenant while they're still residing with you. And you should never let it balloon up too high. And again, if you can ever prevent, utilities being exclusively in your name, that's definitely what we recommend, because there's just so much risk. Okay, next question. We've got a junk car on a property that doesn't belong to our tenant. We're getting code violation notices from the city about it. Can we have it towed to where? Well, I don't know what city you live in, Alicia, but most jurisdictions have some kind of abandoned car tow provisions. And if they don't, then maybe the greater county or maybe something on the state level. But a lot of cities have, abandoned car sorts of ordinances or city codes that deal with that. You may have to, call 411, get some kind of information from your local jurisdiction about that. The procedure is not the same everywhere. And frankly, I don't deal with autos. But when it comes to abandoned property, there are generally, again, this is usually on a city level, options for you to go ahead and call somebody up and get that thing towed. When you say it's not your tenants, are they somehow responsible for it? Is it like a friend of theirs? Is it a former tenant? Is it your vehicle? Is it just some stranger who just abandoned the property there? Those might be important factors. But yeah, generally speaking, an abandoned vehicle, it can be towed. I know in the city of Houston, that's a common thing. And yeah, you just call the city up and the thing gets towed to a public lot. And if the owner ever wants it back, they can pay the fees and get it out of tow. So, all right. So here's the pet one. Please explain the difference in the wording between a pet deposit and a pet fee. Well, this is pretty easy, but can get mixed up, and it's important to get this straight because, generally speaking, a pet fee is not anticipated as being refundable. But anytime you have a deposit, even if you call it a non-refundable pet deposit, in Texas, every deposit is refundable, every single one. And I know you're going to argue, but Ernie, it says right there in black and white. Sure, but that doesn't necessarily mean it's enforceable. So the code, the Texas Property Code says, if it's a deposit and it doesn't go to some specific charge, it's refundable and you got to give it back. And so, but in both situations, you can have, particularly when it comes to pets, to animals on the property, you can have specified charges for the right to have an animal. So here's an easy one. Let's say you've got a rental property, and you say, "Look, I just paid to have all the floors cleaned, all the carpets professionally steamed, and I paid X, $350, we'll say." You agree, if you're going to have a pet and they're going to be in this house, you agree at the end of the lease to pay $350 or to clean it just the way I did. You figure out how to do that yourself and you can get it to the same level of clean that I had it before you took possession, fine. But you either agree to get it just as clean, or you agree that if you fail to get it that clean, I will get it that clean and I'll deduct that amount from your deposit funds. Now that could be the pet deposit, it could be the regular deposit, but you want to be explicit that that's where the cost is going. Now, if you have a pet fee, generally, again, that's not a refundable thing. And so it's a lot easier to say, well, you paid a one-time pet fee, and generally I use that toward cleaning. But where it's important for you to be careful is you don't want to double bill. And so if you say, well, I took this pet fee specifically for pet-related damages. Okay, well, make sure you don't deduct from the regular security deposit for pet-related damages that are supposed to be ascribed to that pet fee. You want to be real clear as to where these funds are going and what these fees are for. So if it's a deposit, it's refundable unless you use it for a specific thing. If it's a fee and you don't actually use it for the thing that it's ascribed to and you pull it out of the deposit, you might be accused of double billing. So be careful with that. Finally, the one that I hate the absolute most, it wasn't part of this question, but I like to mention it, is pet rent. Sometimes people will be cute and say, oh, Fido's got his own pet rent. I really hate this idea, particularly when it comes to fighting over the lease. If it's pet rent, it's either a pet fee or a pet deposit. But if it's rent, it's just rent. So if you're going to pay an extra $50 for Fido to stay on the property and you're going to call it pet rent, don't be cute about it. Just say, fine. What we're going to do is we're going to adjust the rent upward $50 to accommodate for the dog. And don't call it rent plus pet rent. Just call it rent, because rent is always just that. And if you're going to evict somebody, you can't include the pet rent because that's not real rent. That's not a person, that's property. And so that's kind of a fee. And so like a utility fee or a deposit or an HOA violation, you can't include those in an eviction, but you can always include rent. So let's not get too cute. If you're going to charge an additional amount for rent for a pet, just throw it into the regular rent. All right. So, real quick. All right. Question 5. Here we go. Unique the realtor. My tenant created extensive damage to the property, possibly rendering it uninhabitable until fixed. He is in default of his December rent. I did an emergency maintenance inspection and the home now looks to be abandoned. Though he was there 24 hours prior during my inspection, there are no true signs of him still intending to live there moving forward. And the extensive damage. Question, how do I go about taking the property back? If he is not responsive to me and if the damages are left unrepaired, it will cause subsequent damage like mold. Well, I don't know about that, but let's deal with the because that's that last part is a little bit maybe. Let's deal with what is. So there's extensive damage there. It looks like he's gone. The first thing I'm going to have you do, Unique, is to review your lease. Is there an abandonment clause in your lease? Many leases have abandonment clauses that say something similar to the following. In the reasonable estimation of the landlord, it appears that you have abandoned the premises if you are delinquent in that month's rent. In our reasonable estimation, you have vacated the property, and I have given you notice about abandonment, and you have failed to either gather the rest of your things or confirm that you continue to reside on the premises. Now, again, that's a 3-part test. Number 1, they're in default. Sounds like they're in default for the month of December. They're in default for December rent. It sounds like they've abandoned. If they've taken most of their stuff, if not all of their stuff from the unit, you can make a pretty reasonable calculation that they have vacated the property. And then finally, if you've given them notice and they haven't otherwise indicated. So here's where the notice provision of your lease is extremely important. Do you have multiple ways of getting to them? You obviously can't just go visit them at the property, but do you have a regular email, a work email, a personal email, text, the tenant portal, your WhatsApp app? All these things that are mentioned in your notice provision are extremely important, particularly in a situation like this. We've got multiple avenues of getting a hold of them to say, by the way, it appears that you've abandoned the property. Let me know over the next 48 hours whether that's true. If I don't hear from you or do not see evidence otherwise that you are residing on the property, I will presume that it has been abandoned and I will take back possession thereafter. So you give a reasonable amount of notice, because again, it's pretty reasonable to make that determination, but you're going to want to follow what your lease says to cover your bases. What you don't want to do is go in and say, non-payment of rent, looks like they've moved. I'm going to change the locks and take possession right now. Particularly if they are still in the process of moving things out. If you didn't give them fair warning when your lease requires it, you might find yourself on the wrong side of civil litigation, getting sued. They're like, oh my gosh, grandmother's $35,000 brooch was still on the property. And I looked and looked and looked, and now I can't find it. You must have taken it. Now, good luck proving that, tenant, but now you have to contend with this ridiculous claim, and that's going to cost you time and money and frustration. Don't put yourself in that position. Make sure if you've got an abandonment clause, you use it because it's not that complicated. You got a default in rent. You've got reasonable cause to believe they are gone. And then you've given this notice, giving them a reasonable amount of time. Now, I always say give the 48 hours notice or 2-day or 3-day notice, and then wait an extra day or two. So that if you gave, for example, a 2-day notice, a 3-day notice, but you waited a whole week before you took possession, hard to argue that you acted in an unreasonable manner. So there's that. Hope that helps. Tenant is in jail. Now, I would love to be able to pronounce his name, but I absolutely cannot. I hope somebody out there can read it. And if it's you, let me know in the chat. But this is what I got in my question request, and so I left it as is. Tenant is in jail, but he is not done yet. Should I anticipate he will not make bail or wait until rent is due to start eviction? The better question isn't, should I do this if he's in jail? The better question is the tenant currently in breach? I mean, if they're otherwise up to date with their rent payment, they may have mom make the next rent payment and still be up to date, come next month. So don't just presume they're going to breach the lease. If they're current in the lease, don't evict. Going to jail is kind of like going on vacation. There's nothing wrong with him leaving the unit as long as he's still using it properly and paying for its use. And this is why in the previous question with the abandonment, if he's not otherwise delinquent in payment of rent, then you can't make the assumption that he's abandoned the unit. In fact, the continued payment of rent leads you to believe that the unit is not abandoned. So before you go too quickly into the eviction court, I would definitely wait and see, is there going to be a breach? Because without a breach, you really don't technically have cause for an eviction just yet. So I wouldn't get too eager, especially if that rent payment is steadily coming in. And so that's my advice with that. All right, next question. Edward Obie. My tenants vacated the property with damages, of course. I filed a small claims case. He always paid by Zelle, and I do not know if he has a bank account anywhere to seize what he owes me. What can I do to collect on the judgment? Well, so what I tell people, you're already in the thick of it. If you can prove your damage total to the court, and if the tenant has been served, and I don't know just yet that he has been served, but if you can prove it and win it, and the tenant is not like super eager to pay the debt, there's unless you know of, and I'm assuming this is in Texas, And so I'm giving you a Texas-based answer. But, depending on where you are in the country, you may or may not have access to assets that they own. In Texas, for example, even if someone owns real property, if they live there and it's their homestead, totally protected. So you can't seize that particular asset. They would have to own some non-exempt asset, like some lot that they own together with their brother because they inherited it from an uncle or something like that. That could be subject to seizure. But you don't even get there until you have a judgment. So you got a judgment, and now you got to turn that judgment into a judgment lien. So if you're asking me, how do I protect my judgment so that I can collect it? If not now, perhaps sometime in the future, you create a judgment lien. And in Texas, you do that by requesting from the court an abstract of judgment. And then once abstracted, you take that abstract and you go and file it with the county clerk's office like a lien. In fact, you are creating a judgment lien against the individual. Now, why is this important? Well, they might in the future own property that is subject to seizure, and you're going to need this abstract in place in order to execute against that property. But there might be another situation where, for example, they want to buy a property. And the title company does a search on this individual and finds, sure enough, your judgment there, which has been abstracted, and you've got 3 pieces of identifying information attached to that abstract. The last 3 of their social, the last 3 of their Texas driver's license, and their date of birth. This is going to be very hard for them to deny that it is them, right? Because if you sue Jack Smith, and there's a gajillion Jack Smiths out there, but only one Jack Smith with these last 3 of their social, these last 3 of their driver's license, and this date of birth exactly, it's going to be really hard for them to deny that that was them. And so if a title company finds this and says, look, your lender is not going to go forward with this loan until you clear this judgment lien because it otherwise encumbers potentially the collateral, that's when you get a call and they say, what is the cost to release this judgment lien? We got somebody who wants to buy a house. They give you, or you give them the payoff amount, they send you a check, you release that judgment. That's one really good way. Everybody loves that phone call. And from time to time, we're happy to deliver those calls to clients and say, look, I just got a call from a title company. That judgment that we handled for you 2-3 years ago is coming back. And so I gave them the total. I calculated it with interest through the end of this month. They're sending me a check. I'll sign the release. Check's yours. So that's one way to protect it. But again, if there are no assets, I don't know that this is necessarily worth it. Unless you have a reasonable expectation that there will be assets or this person makes an income that makes them subject to potential seizure in the future. Additionally, some people, once they have a judgment, they want to clear it, but that's not most tenants, unfortunately. So, all right. So I'll check the chat one last time. We are on the final question. If you do have a question and you've just been holding back for some reason, I strongly encourage you to ask it because I'm about to wrap things up with the last question. Ooh, it's a long one. Here we go. If the tenant moves out and then texts me to ask me when their deposit will be given back and also tells me to give them an itemized description for anything taken out of the deposit, do I respond with the itemized deductions through text and send them a check through a Cash App since they did not give me a forwarding address? Or should this all be done formally with a certified letter from them? So I'm going to stop right there because there's a secondary question to this. Technically, the law does not require you to send them the itemized deduction list until you get the forwarding address. However, the better question is, why wait? If you've got access to them now, do you know that you owe them a deposit? If so, get them their deposit. They're clearly in contact with you. Don't wait to get sued. Don't wait to have to say, well, as a defense, I technically was not required to give this to them until such and such and such and such. Work with your tenant and figure it out. If you have a deposit and you owe them some amount and they're in contact with you, find a way to get it to them. Yes, if you are going to take deductions from that deposit, always, always, always have an itemized deduction list and give that to them as well. Especially if they left so many deductions that there is no deposit to refund. And so I'm of the mind that it's always a good idea to get the itemized list to your tenant within 30 days, whether they gave you a forwarding address or not. That's the law in the state of Texas, is 30 days from the date of them giving you a forwarding address. And I get it. You're not otherwise obligated. I think it's a good rule of thumb. Do it 100% of the time, and you can avoid some of these ticky-tack lawsuits. But again, make sure you are aware what you can deduct. You can't charge your tenant for damages to the property unless they exceed normal use, unless they exceed ordinary wear and tear. And I tell landlords this all the time, but your tenant is actually allowed to damage your property. Yeah, it's true. They can damage your property as long as it's through normal use or ordinary wear and tear. If they were there for 5 years, yeah, you can expect the carpet to be torn up a little bit. You can expect wear patterns in certain places. You can expect a few scuff marks on the wall that are perfectly normal. Holes in the wall from pictures. Ordinary. These are not uncommon things. And so the court's not going to let you charge money, to fix that up, right? So if, for example, the little rubber units in the toilet wear out, now I got to replace all that. But it happened through normal use. You can't charge these fees to the tenant. And so understand where you can charge them and what you can't. If they punched holes in the wall, that's not normal. If they set fire to the kitchen and, ruined the microwave, that's not ordinary. So you can charge them for things that are not normal use, not ordinary, and that are essentially their negligence. So understand what you can and can't deduct. Make sure you come up with an itemized list, send it to them, and if they're due a refund, get it to them in the most convenient way possible. Don't hold yourself to these formalities, because what's going to happen is you're going to, I'm just going to wait till they do it the right way. I do owe them a deposit. You're going to miss that deadline. They're going to hit you with a formality, and now you got to contend with that in a lawsuit. And now they're not going to accept just the actual deduction. Now they're going to say, I want everything plus attorney fees, plus statutory damages, plus court costs and interest. Avoid all of that mess. If you know you owe a deposit, refund, send it. If you know you've got good, valid deductions, list them, give them that list. And if there's a deposit balance, send it. If you know you owe no deposit balance, make sure you've got a rock solid itemized list of deductions and you get it to them. Don't wait on the formalities. Give yourself a deadline of 30 days and get it to them. All right. Well, landlords, I hope this was helpful to you. I've had a great time this whole year with these lives, sharing this with you. I know a number of you come time and time again. I do want to wish you all a very Merry Christmas. I will be off for the next 2 weeks. I won't be here next week. I won't be here the week of New Year's because of the holidays. And so we're going to take some time off. But we will be back January 7th. Of 2026. We look forward to your questions then. I'll have a whole new topic coming up at that time. Again, I want to wish you guys the best holiday season. I've had a blast doing this. I look forward to seeing all of you again in January. And until next time, landlords, happy leasing.